Kansas Court of Appeals is now in session. The Honorable Chief Judge Karen Hollenberger presiding.
Hello. On the sign of the day. Okay. Seated.
You just want to swap from
Yeah.
Yeah, we just sort of
Fourth
see
senior on the right.
the
Oh, we messed it up already. Okay, I am so sorry for you guys.
we're trying to confuse you.
It's going to decide the case.
It gets better from here.
And we even double checked it with ourselves before we came in. Welcome to the Kansas Court of Appeals morning session. Apologize for these funky glasses I have. I had some cataract surgery and they make me wear these for a few days, but we only have one case on the docket today. It's Johnny King versus Unified School District 501. And before I get the appearances, and the case number is 125117, I'll tell you that generally you each have 15 minutes to argue. Since there is a cross appeal here, I will give each of you 20 minutes, and I'll probably be a little lax with that, even if you want to include the argument with the cross appeal in your first go around. We won't have a double item. We've read the brief, so we're very familiar with the facts of the case. So you really don't need to take your time to do that unless there are particular facts you want to make sure that we hone in on. So introducing the judges with me, on my right is the senior judge on this panel, Judge Stephen Hill, who was a district court for many years in Paola before he came, Miami County, before he came onto the Court of Appeals. To my left is Judge David Bruns, who formerly was a district court judge in Shawnee County and came on the court basically a month or two after I did. We came on at about the same time. So we are happy to be here today. Like I said, we've read the briefs. We've read the transcripts. We've looked at the videotape. So with that, if the parties would go ahead and state their appearances, we'll get started.
Is the court, the appellant Johnny King appears through counsel, Ted Lichtai. Also present is my co-counsel, Terry Lapp.
Okay. Thank you.
Good morning, Your Honors. May it please the court, J. Philip Gregson and Kara Eisenhut appearing on behalf of the USD 501.
Eisenhunt.
Kara, A-A-R-A.
Is Ms. Eisenhunt on the brief?
Yes, I am.
I just we'll need to note that in the opinion that you hear. So as long as you're on the brief, we've got all the information we need. Okay, Mr. Lichtai, did you wish to have any rebuttal time?
Yes, Your Honor, I'd like to reserve 5 minutes.
Okay. You may begin whenever you are ready.
This is a case involving a claim of retaliatory discharge under the Kansas public policy exception to employment at will. Johnny King was employed at Hope Street Elementary in Topeka. There was an event in late May of 2017. Mr. King, some of the other staff and faculty, and a young student. Student was acting out, including to the extent of attacking one of the teachers during the event. The intent was to place the student into a timeout room, which is used to try to calm down students when the occasion arises or the need arises. There was Your Honor mentioned a short video made of the event on a cell phone.
Counsel, it seems to me, in looking at this record, your client did what he was hired to do.
I think that's a fair statement, Judge, yes.
But in the opinion of his employer, he did it incorrectly.
That's correct also. The school maintained, as many schools do, I think, what's called the MANT system of restraint. There are techniques involved that are supposed to be used when the need arises and when the circumstances permit. All of the faculty and staff were trained on the MANT. And so there's no question that that occurred here.
I did have one factual question for you. In this, when this event was occurring, who was in charge? Other than the student who was acting out. But who was in charge?
Judge, there was no particular staff or faculty in charge.
So they were just acting as a group of faculty members collectively trying to control the student.
Of course, I suppose one could say that the teacher in the classroom where the student was the one who decided that the student needed to go into the timeout room. But really wasn't any direction given by that teacher to the others as to what to do or not to do. And so from that perspective, there wasn't any insubordination alleged with Mr. King's actions.
So he wasn't terminated because he wasn't following orders.
That's correct.
Somebody didn't say, hey, don't do that, and he did it anyway. There's nothing in the facts that indicates something like that.
That's correct. Mr. King took it upon himself to come to the aid of the teacher who was being struck. That we would contend is consistent with the MANT system as far as it applied to the situation. It's always been my client's contention that the MANT didn't really apply here because it couldn't be applied given the actions of the student.
The school board is taking the position that regardless of all that, he was an employee at will. So he could be dismissed for cause, for no cause, for any reason whatsoever. Was there any contractual relationship between the school district and Mr. King?
Nothing that was distinct from any other employee, a staff member. He wasn't faculty.
So you would agree that he was an employee at will?
Yes. And of course, our claim is recognized as an exception to employment at will, as long as we meet the threshold for being able to state that claim.
So a public policy exception is what you're...
Yes, Your Honor.
Because I wanted to make it clear, certainly we could look at things and have our own subjective opinions about what was reasonable and what wasn't reasonable, but that's not why we're here. We're to determine whether or not there's a public policy exception and that your client should have been allowed to go submit the case to the jury.
That's certainly the issue on the cross appeal. And then at trial, we had the Rule 50 motion where the elements of the claim itself were at issue, at least 2 of the 4 elements. And probably the primary issue in the appellant's perspective is whether the school district had sufficient knowledge, both in quantity and quality, to understand that King was acting pursuant or consistent with state law, the Freedom from Unfair Restraint and Seclusion Act, and also federal law, the Coverdell Act, which provides immunity, civil liability for those employees in the school building who need to take action to prevent violence from occurring or to end it if it is occurring. And we think that the main point here is that the district was aware of what would be considered protected activity. That is
And what evidence is there of that the district was aware?
It's where simply by the fact that certainly the video and the statements given by those who were present all described Mr. King coming to the aid of the teacher.
It was my understanding that he was the only one that was terminated as a result of this. None of the other employees were disciplined in any way.
That's correct, yes. And of course, part of our pretext argument is that those who were present on the scene were all similarly situated. And it was only Mr. King who was terminated for what happened or didn't happen.
Was there,
Touch the child?
There may have been some interaction physically with faculty and staff when they were walking on their way to the timeout room, but nothing of a type that later happened between Mr. King and the student.
Does that make any difference because he was the only one that touched it and the other employees did not?
It certainly could, because the student was acting out even on the way to the timeout room. And the MANT system directs that those in charge, those with authority, try to de-escalate the situation so that what happened would not occur. That is an escalation of his behavior that included punching the teacher.
their depositions, or was there trial testimony, excuse me, as to what the people that witnessed it viewed it to be at the time? Did those people that were there witnessing it, did they testify that, and they had also had MANT training, because it appears everyone had MANT training. Did they recognize it as being in violation of the MANT protocol?
After the event occurred, everybody who was present gave a statement in one way or the other. As I recall, none of them stated an opinion about whether the MANT had been violated or not followed. At trial, the teacher who was punched did testify. And we did not look to her to state an opinion.
There was some affidavit in there or something from her, wasn't there, that was pretty well, she said that she didn't view it. It seemed like she downplayed quite a bit the significance of that punch.
There was an affidavit from Carla Nolan, who was head of human resources for the district. That affidavit is certainly a main part of analysis. The district court had two different evaluations of the affidavit. Ms. Nolan never testified either at deposition or at trial.
So could the judge have taken that even into consideration when the judgment, motion for judgment as a matter of law during the trial had taken place? I mean, at that point, it seems like the district court judge would have been bound by whatever was submitted to that point at the trial. Is that accurate?
I agree with that, Judge. I think
Because the affidavit could have been considered for the summary judgment motion, and of course, there's the cross appeal. But I'm talking about now what we used to call directed verdicts, but judgments as a matter of law. The district court's bound by whatever evidence has been presented.
agree with that, definitely. And
So could the judge have considered that affidavit if she didn't testify?
we think that he should not have considered it because it wasn't admitted into the record at any point or offered for the record in either.
Was it submitted though for summary judgment purposes?
Yes.
Okay, so because there is a distinction between the two, that's what I was trying to make clear. Thank you.
And we do think there were contrary findings made in the ruling on summary judgment as opposed to the rulings made 50 motion. Do contend that the law of the case doctrine should apply to bind the court from the summary judgment.
Well, let me ask you about that. I've had a lot of cases dealing with the law of the case. And even when I've tried cases, I've changed my mind about what law applies. It's one thing to say law of the case about a case that's 5 years old. And there's another thing that while the case is still going on and the judge hasn't changed her mind or has changed her mind. Isn't that, I'm just questioning whether law of the case even applies here, counsel.
Certainly recognize the right of a judge to change his or her mind. It does happen, no doubt. But when it does happen, think that the parties should understand why the judge may have had a change of mind.
That's well taken. I just am anxious to understand it, whether it's binding or not. I mean, that law of the case is a binding doctrine. And certainly binding upon the parties. And I have another question for you that's more particular. It occurred to me that and correct me if I'm wrong, did the district court say here that Mr. King had to prove that the district knew he had exercised a right? It's my impression that the court did. Is that correct?
Yes, that is correct.
Is that proper?
Not as the order came out.
What did he have to prove?
But we contend that all he had to prove was that there was protected activity, number one. Number two, the district's knowledge included not only what it may not have known, but also what it should have known. And that standard is in our retaliation cases. That is, the employer can't just close its eyes, close its ears.
Is it your opinion that, or is it your argument that the district court went too far when it said that he had to prove that Mr. King exercised a right?
Yes. And there are a couple other ways of looking at that. One is that Mr. King was not required, we argue, to announce or to notify the district what laws he was acting pursuant to. None of our retaliation cases have that requirement. For example, in a work comp case, work comp retaliation case, there's no requirement that the plaintiff in such a case march into the HR office and say that I'm making a work comp claim. There's no legal requirement for that to happen. Maybe a work rule that the company has that would require reporting like that. But as with work comp retaliation, at the outset of the event, it's not clear to what extent there may be even eligibility to receive work comp benefits. In this case, the district should have been at least aware of the basic content of the state regulations and the federal act. And that's part of the controversy involving Ms. Nolan's affidavit. But again, I agree with Judge Bruns that really the affidavit is not or should not be considered as part of the Rule 50 analysis.
To your rebuttal time, but go ahead. if
Well,
you have
just
more
one,
questions,
just a question, because I want to make sure that I understand. I read the briefs, but I may have forgot something. Do you have, or did you cite in your briefs, or do you have now any federal case out there or any case from another jurisdiction in which the Coverdale Act has been used as a basis for retaliatory discharge or wrongful termination claim?
I was not able to find one in my research, and the school district, Mr. Gregson did not cite any such case, and neither did the district court judge.
So as far as we know, this is a case of first impression throughout the United States.
But to the extent of
Whether Coverdale could be used as a public policy argument and for a basis for retaliatory discharge.
as far as we know, yes. But it's not, the claim is not exclusive to Kansas in the sense that other states have recognized that their own laws create public policy on this same point. And so they do recognize the claim.
That's all I have to.
I'd like to reserve the balance of my time for the-
the 5 minutes in rebuttal. Mr. Gregson.
Thank you, Your Honor. Please the court, Your Honors, counsel, Mr. King. I had two really personal connections with this case when it came in. Number one, a couple of decades ago, when I came to the firm I'm at right now, the first case I handled involved a claim of retaliatory discharge for filing a wage claim with the KDOL. At that time, it was in front of a very good judge, Richard Anderson. He declined at that time to extend and expand the exception to at will to include those type of claims. This court subsequently, some 8 years later, said, no, that's a good idea to have this as an exception to at will employment. And I agreed. I've also litigated a number of other cases involving at will versus the exception to at will employment. Candidly, I didn't think this case was close when I got it. I'll get to that in more detail. The other connection was even 2 more decades before my life as an attorney. I worked at the Kansas Neurological Institute for 9 years. I personally received MANT training. I personally was in a position to have to use my MANT training, getting headbutted, kicked, spit, punched, you name it. This concept that MANT didn't apply or didn't work, it is inaccurate.
Let's consider how that relates to a claim of defense of others. I mean, basically, he's claiming he did what he had to do to protect this teacher from being, or para, whoever the person was sitting out there, from being pummeled.
Okay, Your Honor, and I appreciate the question.
I mean, does MANT deal with that situation?
Absolutely.
Oh, it does.
Absolutely. There are allowable physical restraints. I've used it on developmentally disabled children. Okay. And if we want to talk public policy, the public policy here is when we have individuals that we know have a diminished ability to control their behavior, such as we do in this case, an 8-year-old boy, we as a society have said, we're going to try and minimize the potential harm when it comes time to have to physically interact with these folks.
What if this young kid had a knife or some sort of weapon? Would that make your analysis any different?
No. And my analysis is this. Number one, you referenced an affidavit or testimony. It was the testimony at trial of the teacher who was punched, who said she did not consider her life in danger. She did not consider that she was going to be injured.
Say anything when Mr. Kling started his actions.
Okay. There's a continuum of incident here. So the JC acted out. He punched the teacher. Mr. King rightfully assisted
Mhm.
and escorted JC to the timeout room. We don't have a problem with that. That was appropriate. When he got to the timeout room and the folks standing around that you can see him in the video did exactly what they were supposed to do once he started fighting, trying to get out of the timeout room. And that is back away. Back away. He's on the floor. Give him time to de-escalate. You never stop trying to de-escalate the situation. Never. That is why they weren't disciplined in any way. The video is 7 seconds long.
Very fast.
And what happened after that video was ended is they had to tell Mr. King, please back away now. Right? And they continued.
And that
to
was
deploy-
testimony.
Yes, and they continued to employ the de-escalation techniques, and it worked. That's what happened here. There is nothing in the MANT training to say, hey, when a child is on the ground, you can grab him by the shirt and pull him back into the timeout room, or intentionally or otherwise, close the door on his head as he's trying to get out. There was no need to engage in those actions. You let them play it out. It's going to eventually end. The concept that, gee, MANT no longer applied and therefore he could do this is just inaccurate.
I guess my question is, there is never a situation involving a disruptive child that would justify deviating from the MANT requirements. Is that what you're saying?
Well, yes, because the MANT training is relational.
Mhm.
The action that's appropriate is relative to the behavior that they're experiencing. Okay. If this 8-year-old child had a knife and he happened to get hurt in the course of, okay, we got to get this knife from him, that could have been appropriate in that situation. But we're not here to argue that. Okay. What happened is we had an 8-year-old child that was going off. Everybody can see the video. He was upset. And the facts are that Mr. King was told to disengage. He did, and the situation de-escalated. That's what happened here. We had it on video of Mr. King using at least 2 techniques that are in violation of the MANT training. And that's the basis for the termination. And so I don't get too far afield, I am here also arguing that summary judgment was appropriate on the basis of, number one, there is nothing in FERSA or the Coverdale Act clearly that says you can't terminate an employee school district. I think we can all agree on that. It doesn't use those words, right? So what the court is left with is those factors that this court and the Kansas Supreme Court has established, which is there a clearly declared state public policy in either of these statutes to protect an employee from getting terminated or violating the training they received? Sure.
It appears to me that the basic question that we have here is the failure to follow the MANT system a pretextual reason to discharge. If it is a pretext, then that has certain concept. If it is not a pretext, that you see the fundamental difference. The basic question is the failure to comply with the MANT system. Is that a pretext?
Your Honor,
Isn't that the ultimate question we have to answer?
I don't think so. I think the question and what they're trying to say, it was pretext for supposedly exercising right under Coverdale or FERSA. Our stated good faith, uncontroverted reason for terminating Mr. King was that he didn't comply with the MANT training Mant training, that, by the
And,
way,
and the question that we have before it, is that a pretext?
my response is absolutely not, Your Honor.
Okay, that's the question we have to answer. Is that reason a pretext? If it is a pretext, then they win. If it isn't a pretext, you win. Is that how it works?
I disagree, Your Honor. You don't get to pretext unless you first establish that there should be an exception to at-will employment here. Pretext only kicks in under a burden shifting arrangement when they've established all the prima facie
I
elements.
see. I understand that argument.
Okay, okay.
Your argument kind of surprised me the way you started. It seems like you would have started with, this is an employment at will case. And regardless of whether Mr. King acted reasonably or didn't act reasonably, it's an employment at will case. They have to prove an exception. Coverdale and FERSA, in your opinion, is, or in your argument, is not, are not basis for a public policy exception to employment at will. It seems like we've jumped all the way to about the third step in this case, and we're debating about whether or not his actions were reasonable. And we each may have our subjective opinion. Everybody in this room may, but that's not the legal issue before us, is it?
I totally agree, Your Honor, that first and foremost, they have the burden of establishing this is an exception to the clearly established law in Kansas of at-will employment.
If they show that, then the burden shifts over to you to prove that the termination was in good faith.
Yes, that it was not pretextual, that it was for, and pretextual is not that complicated. Can you prove that the real reason was different than the reason we gave? There is no evidence presented anywhere that the reason for the termination is for anything other than his noncompliance with Mant. And I will tell you, if FERSA supports something, it's a public policy that it mandates that school districts will implement Mant training programs. They're required under law to do this. I believe that the district court somewhat substituted its evaluation for how Mant works and all of that for the decision made by the school district. To circle back around and complete what I believe needs to be emphasized here, the Nolan affidavit, and I'm a little sheepish about it, I drafted it, I gave it to her, so make sure these are your words. What supposedly is controversial is a statement, I didn't consider these acts in upholding the termination. There is nothing in there that supports a finding that they were motivated by anything having to do with those acts. That's why I believe summary judgment was inappropriate, because the court found, well, hey, this means maybe they did consider it, when the affidavit said completely the opposite. That being said, as outlined in our brief, we don't believe, if you look at the case law, that FERSA or Coverdell, the public policy exception, those statutes simply don't apply to provide immunization from termination of employment. I mean, FERSA, again, the whole purpose is to protect students and to give parents the avenue to have a hearing. Tell me why you touched my kid. That's the purpose. It's not to protect employees who don't follow the training that's mandated by FERSA.
Does it provide any rights to teachers or paraprofessionals as far as appellate rights or anything like that?
FERSA, no.
Okay. What about Coverdale?
No. Coverdell is if they get sued civilly by a parent. And it's merely,
basically a quasi immunity statute.
yes, yes. And I use the analogy. I've done a lot of 42 USC 1983 cases where you have the concept of qualified immunity. You see these in excessive force cases a lot. A police officer can get terminated for violating policy. That doesn't mean if they got sued civilly, they couldn't still use qualified immunity, because different little standards. I use that analogy at the argument, the judge was not
Would it make a
impressed.
difference, or was there any evidence presented that other people at the school district had failed to utilize the MANT process properly and had not been fired? Would that go to pretextual? That it must not have been because he violated the MANT policy, because you have failed to terminate people in the past that violated the MANT policy.
I'm not aware of any evidence like that being in the record, Your Honor.
And that was not alleged.
No,
Okay.
not,
And would it make a difference if it was?
well, theoretically, but you'd have to be able to evaluate the facts to know how similar they really were, and whatnot. The district isn't here to say, gee, this is all easy. It's not. When a kid's going off, it's, but guess what? You're supposed to follow your training, and if you don't, there are consequences for it. And that's the crux of what this case is.
Was anybody in charge on this? Is there any rank of authority or anything? There were several people around there. Anybody in charge?
Your Honor, there certainly is nothing in the record where we said the teacher was in charge or so-and-so was in charge. Again, recalling my personal experience, when stuff like this happens, it's okay, anybody in the area who's received this training,
They all come in.
we're all responsible for keeping the children safe, right? And counsel did argue, gee, these other people were standing around. Again, they were doing what they were supposed to, which is let this play out, let it de-escalate. He's obviously getting more and more upset because of the physical interaction. That's what should have been done. That's what eventually happened.
Well, we don't know if he's getting more and more upset because of physical reaction by Mr. King, or if, he was out of control, it appears to just a reasonable observer, out of control when he punched the teacher. And that's kind of the limit. That should be the limit for anybody. So he punches the teacher. They try to get him subdued. He's in such an agitated state. I mean, this is 2020 hindsight here. I mean, if, let's say, for example, it didn't de-escalate, the rule is you don't force them into that room if they don't want to go, but he then runs. Maybe he's a runner.
Mhm.
And he runs out into the middle of the street in front of the school, or he runs to another room to grab a kid to hurt him, or there are a whole parade of horribles that could have happened as well if it didn't get de-escalated.
Your Honor, I understand your point, and again, not to talk
Uh-huh.
about myself, I've been in those situations. I've run down the street trying to get individuals.
Right, so,
And-
and I
and
really
what-
don't, I appreciate your experience, but that's not
But-
evidence in this
Yeah,
case.
Well, I know, but the question is, Your Honor, does MANT not apply because those situations occurred? That's not true. It always applies. You do what you can based upon the situation as it's occurring.
Mhm.
At the time that JC was in the timeout area, nobody was getting punched. I asked Mr. King, he said he wasn't afraid of getting hurt. That's his own testimony.
Right.
Okay, the punching had stopped. Mr. King appropriately escorted JC to that location. JC was like, I don't want to go in there. And we all saw how he reacted to it. I mean, we can speculate, well, what if this, what if that? And I agree, there could be cases somewhere in the universe that might change it, but that's not what we're dealing with here. Anyway, I don't know what my time is, but,
You've got about 5 more minutes.
oh, great. I would just like to
Of
emphasize.
course, I'm not seeing real well right now. But you have until 9:50. Is that about 5 more minutes?
Thank you, Your Honor.
Okay.
I do want to emphasize that as set forth by this court in Riddle v. Walmart, before court is justified in just declaring the existence of a public policy, the policy should be so thoroughly established as a state of public mind, so united and so definite and fixed that its existence is not subject to substantial doubt. I believe our argument here today, at a minimum, class would say there's substantial doubt about whether this should ever be considered a public policy exception. I believe if you look at the line of cases, most of them from this court, you have this fairly objective incident that occurs when someone has a work-related injury, or they file a work comp claim, or they file a wage claim. It's an overt act. Everybody can see it. And then there's a reaction by the employer, which everybody can see. I don't know what this would look like, frankly, if it was a recognized public policy exception. What would a district have to do? Have a excessive force evaluation to see, golly, if this was this, or it could have been this? This was clear that those individuals who reviewed the conduct of Mr. King did MANT training. They were MANT trainers. They know how the policy works. And they all said this violated MANT. I believe that the district court here disregarded that and said, well, I don't think it did, or I think even used the language, MANT no longer applied, which I don't know where that came from. It always applies. It always applies.
I think there was a thought that the fact that the child struck the teacher, it became a defense of others situation that outweighed anything in the MANT. You see, I mean, what if it had not been Mr. King, but the police had arrived on the scene, grabbed the kid, handcuffed him? Very traumatic, probably not the right thing to do, but
Right? We couldn't have fired the police.
right.
I mean, we don't have
I-
control over that.
I know it doesn't go to the MANT training and isn't particularly applicable, but you know, they'd called the police. It was severe enough that they called the police because they believed, I am assuming, they were going to need help with this young man.
I think,
See, that maybe wasn't hamstrung by the MANT technique.
Your Honor, I don't know that that's in the record anywhere. It's
You know, it's in the record that they called the
that the
police.
police were called. But again, unless I assume you're all familiar with Hope Street at that time, that's for at-risk youth.
Right.
You know, so.
What the district court did here.
Sure.
Because if I understand correctly, and now I'm kind of flipping, starting with your cross appeal and then moving to the appeal. So the cross appeal really arises out of the denial of your summary judgment.
Yes, Your Honor.
And basically, it seems like the judge was saying, well, I'm going to give them the opportunity to see what they can come up with in the way of evidence. Some of the things we've discussed here, and maybe they could have, maybe they couldn't have, but they didn't, it sounds like. So we're at trial, and the judge isn't necessarily saying, at least as I read what I consider the final judgment, not an interlocutory judgment on summary judgment. The judge isn't even really discussing whether or not public policy is or is not violated. He's saying, I'm going to skip to whether or not there has been a showing of pretext, and flat out says there was no evidence in the record that any other teachers had physical contact with the student. So it looks like that's what the judge was considering similarly situated. Is there any evidence in the record that the other teachers had physical contact with the student? And I'm talking about the trial record, because at that point, that's all the judge could consider.
Well, if you consider the teacher's testimony that she got hit, that was physical interaction.
Well, that's her receipt of physical.
Right, but that is physical interaction. Or if you're talking about initiated by the staff member, I don't believe so, beyond Mr. King's testimony that he stepped in and was escorting him. No.
Because it seems like that's what the district court's hanging its hat on, and then goes on to say, well, even if there was no evidence presented to show this wasn't good faith. Now, some could argue maybe that you would wait until the defense has presented their case to know whether it's good faith. But I'm just trying to figure out, because really our issue is we may not even get to the cross appeal if we decide that the district court was correct on the granting judgment as a matter of law.
I agree, Your Honor. My position would be you don't get to that issue if you grant our cross appeal that this should have been kicked at summary judgment.
So the real issue we have to look at is whether there was enough in the can, so to speak, in the record at the trial to survive a judgment as a matter of law.
Assuming this court first adopts the law that there is a public policy exception here.
Or do what I think the district court did and just said, well, even if we assume that.
Yes,
I
But
guess I would add to that, in this case, would it be anything more than, I guess, if we determine that the district court was correct in deciding this as a matter of law, would it be dicta for us to go to address your cross appeal at that point? Is the school district wanting an opinion on public policy, the public policy issue of Coverdale?
well, I think we do.
Yeah.
I mean,
Well,
frankly,
That's why you're,
Yes,
Yeah.
that's why you're pressing the cross appeal. You want a clear statement from this court so it protects you in the future. I mean, that's an obvious thing, correct?
absolutely, absolutely. And
But whether or not we do that is because we don't give advisory opinions, and that's what you're asking
Well,
for.
you know,
If what the court did was correct.
right. And I mean, I think we would.
And
live-
if Judge Bruns's reading of the district court's position on the summary judgment motion is all, that we also buy into that he really wasn't, he was just gonna hold off until he heard all the evidence.
However, the
Mhm.
ultimate result, if it ends up in there not being a recognized cause of action, either because it's not considered by this court or a definitive statement, sure, that's what we want. My last point is this. Really what happened at court. Again, I don't believe there was a prima facie case made, period. And that's why I moved for judgment as a matter of law. There was no evidence saying that USD 501 was motivated by squelching any rights under these acts. There is no evidence of that, none. And with that, unless your honors have additional questions,
I do on law of the case. I just
Sure.
want to make sure Judge Hill asked Mr. Lechtag about that. I've always thought, and maybe I thought wrong, tell me if I'm wrong, that a summary, an order on summary judgment, whether granting or denying, unless it's a final judgment and resolves all the issues as to all the parties, it's simply interlocutory, can be changed at any time.
well, I certainly agree that that's possible, Your Honor. Does the district court reserve the right to say, hey, I think I got this wrong, it's really gonna be this? Sure, why not? I believe that's the
Up
case.
until a final judgment.
Up until a final judgment. Now, I don't know if it was reflected in the record. We did ask for an interlocutory appeal. The judge recognized that he was establishing new law. The interlocutory appeal was not obviously granted.
We probably denied that. I don't know. But yeah, if we were wise, we denied it.
So, if that answers
Yeah.
your question, Your Honor.
Just want to make sure that both sides had covered that issue, because that is an issue, law of the case.
Yes. Your time.
Thank you very much. You have 5 minutes rebuttal.
Your Honors, as I've just heard the school district's argument, they take a couple of extreme positions. One being that the MANT always applies. That de-escalation attempts never end. And
The de-escalation attempts what?
never end.
Never end, right?
And Judge Arnoldberger, you had the example of, or the hypothetical, what if the student had a knife? I would take it farther than that. And in today's world, these things happen. There's violence in our schools. There are mass shootings in our schools. What is someone in the position of staff or faculty to do when that happens? We would expect them to come forward and attempt to, in some way, disarm or disable the shooter. We don't want people in a school thinking, well, you know, they fired Johnny King for dragging this kid a few feet, maybe a few inches. I just don't want to take the risk that I'm going to be fired for apprehending this shooter. Now, this is a case of statewide importance for that reason. If this court does not recognize this public policy exception, that element of doubt will come into play. And I think that is wrong.
Could you tell me, I know it's your rebuttal time, could you tell me succinctly what your position is on the cross appeal?
Judge, I understand school district's argument and frankly expected it because it is or would be a new claim. Where I find difficulty with it is I don't see an explanation as to why the laws in question do not state with definiteness and completeness what state public policy is on this question. And I must say, there was a statement that there was no evidence of any retaliatory intent offered. I think the school district is looking for some kind of intentional express intent. These cases are largely turning on circumstantial evidence. The employer never comes out and says, "Oh, Johnny, we're firing you because you violated or you weren't protected by the statutes involved here." It just doesn't happen. The other statement I picked up was that what should have happened was that everybody should have stood around and let it play out. Well, what does that mean? In a sense, you're sanctioning violence when you say that, because there's no indication the kid would have stopped. And for whatever reason, he did stop, but only after Mr. King intervened. The issue of the reasonableness of the force is still going to be an issue in these cases. That is, let's say Johnny King pulled out a knife and stabbed the kid fatally. That would probably be unreasonable force under the circumstances and probably bar a recovery in this kind of a claim. Statement was that the pounding had stopped. I'm not sure there's any evidence of that in the record. It didn't stop until Mr. King pulled the student off the teacher. And remind the court with regard to Rule 50, there was no testimony, no evidence presented by the school district. That means all of the evidence should have been viewed in the light most favorable to the plaintiff in this case, non-moving party. And we think the district court did not do that. I don't think I have anything further.
Thank you very much. Thank you both. We appreciate your arguments. It's always a pleasure when we have good attorneys, good briefing, good arguments. It helps make our decision. Well, it's never easy, but it helps us get the pathway correct, I think. So thank you both. We appreciate your arguments today. We'll take this matter under advisement. try to get an opinion out as soon as possible. Okay, thank you. Board of Stand in recess.